Vrijeme je da započnemo sa stručnim predavanjima na ovu temu. Prvo izlaganje na ovu temu održat će gospodin Oetheimer iz Agencije Europske unije za temeljna ljudska prava. Mr. Oetheimer, welcome and thank you for coming.
So I'll assume I'm alone. Good morning, ladies and gentlemen. It's a great privilege and a great honor to be back in Zagreb. I calculated last night, thanks to the internet, I was able to get to a very old database that nobody uses anymore. But when I used to be at the Council of Europe, I was using it. Last time I was in Zagreb was in February 2004. This is the traces that I leave on the internet, and I'm extremely glad to be back. I'd like to thank the Croatian presidency of the Council of the European Union, and of course, the Croatian Personal Data Protection Agency for the tremendous work that they managed to do in a fairly short time to put together this conference and inviting the Fundamental Rights Agency to speak to you today. I find it extremely topical to mark Data Protection Day by addressing one of the most pressing new challenges we face in the area, that posed by artificial intelligence. Within this wide-ranging topic that we will probably have time to discuss along the day, this morning I will focus on the specific issue of data quality in artificial intelligence and how that relates to data protection framework. I will draw on the findings of our recent paper on this issue that some of you might have grabbed when coming here. It brings together several strands of FRA work on data protection, of course, on artificial intelligence, and also for a research organization like ours that works every day with data on data quality. In doing so, I'll raise questions rather than provide clear answers. However, I hope that these questions can serve to support further reflection on this important issue. And again, I know that we have a panel later on that could address some of them. The FRA paper on data quality, which came out in June 2019, is one of a series of short reports stemming from our wider project on artificial intelligence in EU member states, its positive and negative impact on fundamental rights. To set the scene, I think it helps to underline the range of fundamental rights affected. Since technology is extended in many areas of our life, AI interferes logically with a number of fundamental rights. And this slide shows a few, probably the most obvious rights, all protected by the EU Charter of Fundamental Rights, such as the right of private and family life and data protection, of course, gender equality, freedom of information and expression, and non-discrimination. In addition, the right to effective remedies and fair trial, as well as the principle of good administration, are also extremely important in this context. These are just, as I said, some of the most obvious rights, but if you look at other areas in which AI is used, you will see that virtually all fundamental rights are affected by its implementation. Let me just dwell for a second on the potential for discrimination when using algorithm. Often people assume that technology is neutral, but this is not true. The data protection framework is very relevant in this context. In a focus paper that we published last year, in fact in 2018, we highlighted the importance of data protection principles and the way they can be used to detect and avoid discrimination, including, for example, the requirement to carry out impact assessments, be transparent, and provide meaningful information about the logic involved in automated decision-making. And as you all know, the drafters of the GDPR were well aware of this and included a special recital referring to the risk of discrimination in recital 75. When looking at fundamental rights as a whole, you need, of course, to take into account the possibility of the balancing between rights. And this is particularly true in the area of data protection, which, as you know, is not an absolute right, and therefore need to be confronted with other rights. Let me just take an example. If an algorithm is used to check whether it discriminates against certain religious groups, information on religious affiliation needs to be collected. But as you know, this can be sometimes challenging in terms of data protection. And this is the balancing exercise that needs to be performed. Let me now turn to the links between data quality and data protection. Underlining the importance of ensuring data protection and privacy rights are upheld in the context of automated decision-making and AI is nothing new. As you can see from these slides, discussions were taking place some time ago. The recommendation of the high-level group set up by the Commission on AI call on policymakers to consider, and I quote, whether the GDPR mandated transparency and explainability offers sufficient protection in light of the limitation of its scope to the processing of personal data and the fact that automated decision-making processes can also significantly affect individuals when the system is not fully automated or based on non-personal data, end of quote. As a way of answer, maybe, the Commission noted the relevance of the GDPR to the development of AI in its July 2019 communication. I quote again, the rules laid down in the regulation, the GDPR, provide a general framework and contain specific obligations and rights that are particularly relevant for the processing of personal data in AI. These include transparency requirements, such as the obligation to inform about automated decision-making and to provide meaningful information. But to understand the role and impact of data quality, it is useful, I think, to discuss the different types of data used in machine learning algorithms. The illustration gives you a simplified overview of the different data sets and how they interact, namely training data, unseen feature, and inferred labels. Looking at these three types of data helps us to understand the data we are dealing with and where fundamental rights issue, including data protection, might occur. Machine learning algorithms are built based on so-called training data. Such data include information on desired outcomes and information that could be used to predict these outcomes. For example, they cover information on internet behavior, such as browsing history, and whether visitors have clicked on a certain ad, combined with data on possible possession of the user, for example, which smartphone a person bought. Once an algorithm is deployed, it is fed with new unseen features from individuals whose data was not included in the training data. For example, the browsing history could show that a person reads business news online and has bought the newest smartphone. These unseen features are then fed into the algorithm to predict or infer the label for this specific individual. And then we obtain the last step, an inferred label. In this example, it would be that the individual, based on their browsing history, has a high income. This inferred label is not certain because any algorithm works with probabilities. Put simply, we don't know for sure if the inferred label is true or not. To our knowledge, there's been little focus on the data protection aspect of data quality. In this context, I want to highlight three particular issues. Firstly, data accuracy in the GDPR is related to data quality, but only narrowly, as it focuses on the obligation to keep personal data accurate and up to date. Accuracy is usually interpreted as correctness of personal data for one individual. Is the age of one person in the database correct, for example? However, the concept of data quality in AI includes also representation errors, for example, when the data do not reflect the population they should. That apply to wider population as well as the accuracy of inferred labels. We should therefore assess whether the term accuracy could be interpreted more widely to encompass some of these issues. I revert the question to our data protection authority in the room. Secondly, the GDPR covers the important rights of access, rectification, erasure, data minimization, which was mentioned earlier, and data and security of data, as well as meaningful information, which all topics are extremely relevant for data quality. These provide a possible framework for action to address data quality. Thirdly, the use of data in AI-related technologies is not limited to personal data. Decisions may be made about individuals on the basis of anonymized or non-personal data. For example, decision on access to services can be based on statistical prediction based on group characteristics, such as postcode, occupation, and other anonymous traits. In such cases, data protection legislation may not apply. To consider this issue in more detail, let me turn to the simplified presentation of the different types of data sources used for building and deploying algorithms. Training data might be used in an anonymized way or in a way that is in line with data protection legislation. However, when using data for algorithms that aim to predict something at individual level, training data are unlikely to be fully anonymized. This means that training data can only be used if the people that contributed their data have consented to their data being used for the purpose of building algorithms. This is similar to creating statistics based on individual data, in fact. This would mean that people need to have consented to their browsing histories and ad clicking behavior being used to build prediction for future algorithms. The principle of informed consent might be challenged nowadays, though, because it might not be clear to people what they are actually agreeing to when it comes to using data for building algorithms. Furthermore, in some cases, data could be anonymized, as I mentioned before, for creating algorithms. Such data are, however, of limited use for algorithms that predict outcomes at individual level. Because for algorithms to be accurate, a lot of information is needed about individuals. If there is a lot of information about individuals, they might be easily identified, even in the absence of direct identifiers such as name and addresses. Turning to unseen features, as with training data, people need to consent to having their personal data fed into any algorithm which will produce prediction about them. We see this when browsing the internet. Individuals need to agree that their browsing history is used to predict their preferences. Or when registering at an employment service, people need to consent that their demographics are used to predict their likelihood of finding a job. However, as before, the issue of whether any consent is truly informed consent is particularly important at this stage. People might not be aware of the full extent of the consent they are giving and the potential implication, the use of their data for prediction. Questions of the reach of data protection legislation emerged in particular when it comes to the determination of an inferred label. As two authors, Tene and Polonetsky, argue in 2012, in the big data world, what calls for scrutiny is often not the accuracy of the raw data, but rather the accuracy of the inference drawn from the data, end of quote. It is not clearly established in the law whether inferred labels, predicted attributes, or information about individual deduced from other information constitute personal data. For example, is the likelihood of a user with a particular IP address clicks on a particularly advert personal data? Or is the likelihood calculated by an algorithm on the basis of an algorithm trained on historical data of a person newly registered as unemployed finding a job personal data? If inferred labels are considered personal data and so covered by the GDPR, question links to the GDPR implementation will need to be addressed. Is there a right to access to information, a right to deletion? And what about the right to information? Given the accuracy of predictions has increased considerably in recent years, algorithms can generate a lot of information about individuals based on other data. So this is likely to become an ever more pressing issue. And this is where data protection authorities' decision, judgment by national courts, or even the court in Luxembourg will surely provide more clarity on this question. In this discussion, it is important to keep in mind that even as predictions become more accurate, inferred labels are subject to uncertainty. However, we know that the use of inferred labels can have strong impact on the individual lives. Apart from accuracy, the need to assess data quality in algorithms derives directly from the data protection principle of accountability and transparency. Not only when it is related to automated decision-making, but also when processing personal data, data controllers can be held accountable and be transparent. Here we run into questions of copyrights or intellectual property, which can make transparency difficult. Nevertheless, and whether or not inferred label can be considered personal data, automated decision-making about individual is still covered by the GDPR. Data controller must provide meaningful information about the logic involved, as well as the significance and the envisaged consequence of such processing for the data subject. The quality of the data used for developing algorithm can be seen as one aspect of being able to understand the logic, significance, and consequences of automated decision-making systems through algorithm. This makes a description and assessment of data used to train an algorithm an essential component of provision of meaningful information about it. An important question related to this discussion is what, in fact, constitutes automated decision-making. In practice, there might be very rarely any cases without a human in the loop, which does not necessarily reduce the importance of providing meaningful information. Let me conclude by emphasizing 3 points. Firstly, I think you understood, and it's well known, poor quality data can negatively impact fundamental rights, including data protection. You all know the maxim, garbage in, garbage out, and this is one good to remember. Secondly, robust assessment of data quality can help avoiding negative consequences. There are no agreed standards so far for such assessment in the context of machine learning application, but the social science offer guidance about the sort of questions that should be asked. This could be phrased in the following manner. Where do the data come from? Who is responsible for data collection, maintenance, and dissemination? Who is covered by the data collection? Who is underrepresented in the data? Is there information missing within the data set? Answer to these questions can be included in dataset descriptions, which provide information on the content and therefore quality of the datasets. This increases transparency and allows data quality issues that are important for understanding how a certain algorithm works to be addressed. Finally, thirdly, from data protection point of view, more research and reflection is needed in order to understand where algorithm and AI are currently being used and how and what data are used in such example. And this is precisely why the Fundamental Rights Agency is currently carrying a project on AI, trying to understand its practical application and its impact on fundamental rights. Thank you.